Good afternoon. My name is Steve Schaefer, and I'm the director of the Federalist Society's Regulatory Transparency Project. We are happy that you are with us in person as well as live, or if you are listening to this later on. Today we are pleased to host our luncheon discussion, Equality and Equity, Contemporary Debates about Civil Rights in the Era of DEI. Note, all expressions of opinion are those of the experts. At the end of this panel discussion, there will be time for audience Q&A. Just as a friendly reminder that this is an opportunity to ask questions of the experts and not have just statements. There's a lot of very thoughtful people in this town, but we'd like to hear from our experts. Well, first I'm pleased to introduce today's moderator, the Honorable Linda Chavez. Linda is the chair of the Center for Equal Opportunity, also known as CEO. Linda has held many appointed positions and has served on numerous corporate and nonprofit boards. Among her appointed positions has been chairman of the National Commission on Migrant Education, White House Director of Public Liaison, staff director of the U.S. Commission on Civil Rights, and member of the Administrative Conference of the United States, also known as ACUS. She has also written many influential books as well. Linda, I'll turn it over to you. Thank you.
Thanks very much, Stephen. It is a true pleasure, and particularly to see this terrific audience today. And I know we have some other people who are joining us via Zoom. So thank you so much for being here and for participating. As Steve suggested, I am Linda Chavez, Chairman of the Center for Equal Opportunity. And it's particularly important to me that we are having this discussion today because it occurs near the first anniversary of the Students for Fair Admissions cases against Harvard and North Carolina. Those cases were argued and then decided just about a year ago. For those of us who have long opposed racial preferences in education, employment, and government contracting, the decision validated our view that neither the Constitution nor the Civil Rights Act permits race to determine admission to college or professional and graduate school. In the words of the court, eliminating racial discrimination means eliminating all of it. Today we'll discuss the role that the Civil Rights Act has played in the 60 years since its enactment in our understanding of non-discrimination based on race, especially in the era of diversity, equity, and inclusion. In our discussion, I hope we will delve into whether the Civil Rights Act requires more than non-discrimination. There's a lively debate with advocates from both the left and the right on whether the act itself is the progenitor of an anti-racism agenda. And it is the point especially that we will be addressing today. We are very pleased to have with us three panelists, starting off with our lead panelist who will present a paper, GianCarlo Canaparo, who is a senior legal fellow, Edwin Meese, the Second Center for Legal and Judicial Studies at the Heritage Foundation. He's written many law review articles, including those that appeared in the Harvard Journal of Law and Public Policy, the Notre Dame Law Review, the Georgetown Journal of Law and Public Policy, and the Texas Review of Law and Politics. In addition to researching and writing, Canaparo co-hosts a podcast on the Heritage Foundation's SCOTUS 101. It follows the Supreme Court arguments and opinions and features interviews with judges, advocates, and scholars. Canaparo served 2 years as a law clerk to a federal district court and spent 3 years as an associate at the law firm of Skadden Arps. Following GianCarlo's presentation, we will hear from two panelists who will respond. The first is Dr. Jesse Merriam, who is an associate professor of government and pre-law advisor at Patrick Henry College. He is also currently a research fellow at the Claremont Institute, Center for American Way of Life, He has a PhD in judicial politics and legal theory from Johns Hopkins, a separate MA in philosophy from Johns Hopkins, and a JD from the Georgetown University Law School. We will then hear from Aditi Juneja, and Aditi is the Executive Director of Democracy 2076, a time that I will not live to see, I don't think. An organization founded in 2023, working for long-term change to our Constitution, political, cultural, and political parties. She has also worked for Governor Andrew Cuomo on housing policy, enforcing the Fair Housing Act and the Civil Rights Act. And her writing has been featured in Vox, NPR, Talking Points Memo. She received her JD from NYU Law School and a BA from Connecticut College. So without further ado, GianCarlo, it's all yours.
So first, let me take a moment to thank the Federalist Society for inviting me to this panel, and to my panelists, who I'm delighted to join, and for all of you for coming to discuss the Civil Rights Act of 1964. The Act remains, as it always has been, the subject of great debate. You will find proponents of the Act on both sides of the political spectrum, or rather on all sides of the political spectrum. The Act, of course, was a product of its time, so the primary evil at which it aimed was Jim Crow, which principally targeted Black Americans. But the Act and the civil rights movement which birthed it were aimed not at that specific evil, but at the general evil that says it is right to discriminate against another person based on his or her skin color or origin. For that reason, the Act's terms are universal. Its preamble declares its intent to protect the constitutional rights of all Americans, and its various provisions apply to any individual, all persons, and all citizens. To proponents of the Act, the wrong to be remedied was the choice to discriminate. So the Act's text forbids that choice, regardless of who makes it or who suffers from it. But consider then, upon reading the Act, how confused you might be if you looked around and saw universities discriminating on the basis of race against Asian and white applicants, businesses giving special preferences to customers of certain races, employees demanding segregated trainings, students demanding racially segregated housing and graduation ceremonies, and state and federal agencies dispensing and denying benefits on the basis of ascriptive qualities. Imagine how confused, too, you might be if you picked up a best-selling book on anti-racism and read that the mere existence of racial disparities, no matter their cause, is not only immoral, but a greater immorality than the choice to discriminate against another person, such that, to quote one of these best-selling books, the only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Is the Civil Rights Act to blame? Some people argue, and argue well, that it is, although the Act is focused on protecting individuals and on prohibiting an immoral choice. It was inevitable, they would argue, that that approach would devolve into a focus on groups and group outcomes. Others say that the Act itself is not to blame, but rather that subsequent judicial and legislative developments were, like the disparate impact theory of Griggs versus Duke Power and United Steelworkers versus Weber, which were codified in the 91 Amendment, which also changed Title VII's damages remedies for the worse, as they would argue. Now, I'm only a moment into my presentation, but I'm already going to disappoint you all. I am not going to answer that question. Is the Civil Rights Act to blame? The reason being that I can't answer that question. To answer that question well, you would have to untangle thousands of strands of causation and trace them to their myriad results. That is a worthy work, to be sure, but one which I think in me would find an unworthy worker. So what can I do? It occurred to me that law is more than just a mechanism to distribute goods, more than a mechanism to prevent harms. It involves more than material and utilitarian considerations. Law is also a teacher. Going back to Aristotle and Aquinas, they argue that the major purpose of law is to lead human beings to virtue. So it occurred to me that if you wanted to pass judgment on the Civil Rights Act, you would have to account not only for its material effects, not only for its effects upon the American constitutional regime, but its effect on human souls. So the question is, has the Civil Rights Act of 1964 made Americans more virtuous? For law to make humans virtuous, two things must be true. It must teach a lesson which is objectively good, but it also must teach that lesson effectively. Two examples of how law can fail to do this. Law could teach a lesson that is bad. The segregated train law that was the subject of Plessy versus Ferguson taught Americans that black people may occupy spaces with white people only insofar as they are in positions of subservience. Not a good lesson. However, a law could aim at a principle which is indeed moral, but fail to teach it. So imagine, if you will, a lawless town in the Wild West where the favorite pastime of the inhabitants is to get drunk. The mayor could stand on the steps of City Hall and announce to the people, drunkenness is outlawed. What happens? Well, I think we know what happens, right? The rootin' tootin' banditos of the town go to the mayor and they say, Mayor, you're right, we've seen the light. Your good and noble law has convinced us to change our ways, and from henceforth we will be sober. Or maybe not. Maybe they laugh at the mayor. Maybe they laugh at the law itself. Maybe they deride the rule of law itself, which had the audacity to array its powerless self against their self-interest. Ultimately, what happens in that situation is that the law gets out ahead of culture and finds itself butting up against culture directly. And typically when that happens, if the law and the culture come head to head, the law, not the culture, is dashed to bits. So the point is that although law teaches, it only teaches well if it teaches effectively and teaches a good lesson. This raises three questions. What should law teach? How should law teach and not teach? And how do you tell if the law has taught well? It's hard to develop a framework to answer those questions in general, but particularly difficult in a pluralistic republic like ours, which is not only enormous, but values choice for its own sake and provides nearly limitless conceptions of the good from which you might choose. Lucky for me, there is a very interesting book, this one called Law's Virtues by Professor Kathleen Cavaney, who wisely covers both bases, temporal and eternal, in her life by being a law professor and a theologian. And she has laid out a framework which attempts to do just that for a pluralistic society like ours. I have adopted her framework, and I have amended it slightly for reasons which I won't go into here, just for the interest of time. But in short, borrowing from Cavaney, I argue that coercive laws, like the Civil Rights Act, those are laws which prohibit certain behavior under threat of punishment, must do four things in order to teach well. They must show citizens a positive vision of how they should live their lives together. They do this first by making available a range of good choices from which people may choose, by protecting the freedom to make those choices from coercion from bad actors, and by limiting the range of evil choices which may be selected. They do this second by fostering a sense of civic friendship amongst all the people, reminding them that they are citizens, countrymen, and equals, not islands in a sea of faceless forms, or members of isolated tribes grouped together only by international borders. Second, coercive laws that are good teachers signal lawmakers' hope that citizens will not merely comply with the law, but will embrace its positive vision for their lives generally. The third, the laws do not punish people for not being virtuous, but limit themselves to punishing only vicious external actions. And finally, they move with a speed and force prudentially tailored to the nature and customs of the people they govern. So let me briefly apply each of these to the Civil Rights Act of '64. A positive vision of living together. Although everyone knew that the specific evil to be addressed by the act was Jim Crow, the act was universal in all of its terms. Its protections, again, were for all individuals, persons, and citizens. No poll worker could discriminate against black voters, but neither could a poll worker discriminate against Mexican, white, or Chinese voters. No employer could fire someone because of his race, but likewise the act prohibited him from being required. It did not force him to hire someone because of his race. No school board could keep white and black children separate, but neither could school boards assign students on that basis to overcome racial imbalances. Recall that proponents of the act and their abolitionist predecessors like Frederick Douglass, John Bingham, John Hale, fought for black people not because they were black, but because they were people, and the act did the same. What's more, it protected a wide array of choices that Jim Crow had forbidden. The freedom to speak in favor of civil equality was protected now. The freedom to associate and to worship with people of different races was protected. Second, the Act hopes for a broader embrace of its vision than it can enforce. The Act recognized that there is no legitimate difference between people of one skin color and another that justifies differential treatment within any zone that the Act could reach. And so it implied that there must not be a reason to exclude people from zones that it could not reach. And it implied, too, that if there was no just reason to exclude people from zones beyond the Act's reach, there was no just reason to hate people on that basis either. But the Act did not attempt, and this is the third point, to outlaw private thoughts or actions, but limited itself only to restricting one particularly immoral external action, the choice to discriminate. People remained free to hate if they chose. They remained free to say horrible things if they chose. They remained free even to discriminate in their private clubs and private associations if they chose. Now, on this point, I have seen it argued that to prohibit some types of discrimination in some spheres will inevitably lead to prohibiting all sorts of discrimination in all spheres. But this is true only if we lack the means to distinguish between moral and immoral discrimination. We do not. Nobody thinks it is unreasonable to discriminate against people with my particular stature if you're hiring a linebacker. Likewise, no one thinks it's inappropriate to hire somebody of Shaquille O'Neal's stature if you're hiring a jockey. And no reasonable person thinks it's inappropriate to limit that a Christian church should hire a Christian to be a minister. But reasonable people would not say that it is appropriate to discriminate on the basis of size or religious stature if you are hiring, say, a computer scientist. We do this sort of thing every day. We draw the lines between permissible and impermissible discrimination. Finally, I think that the Act was prudentially tailored to the customs of the people at the time. What was most remarkable after the passage of the Civil Rights Act was that, as historian C. Van Woodward observed, it was greeted not with a wave of defiance that so many predicted, but with a wave of peaceful compliance everywhere but in certain rural parts of the South. No doubt, this was likely due to the cultural groundwork laid by the Civil Rights Movement, with its explicit embrace and appeals to Christianity and its long suffering in the face of violence, shifted hearts and minds. This has necessarily been a very truncated summary of my argument, but what I conclude is that the Act has been a good teacher of virtue. But the question now is it still? If the Act was a good teacher of virtue, then the people have been changed, but likewise, the American people are changed by all sorts of things, developments in philosophy, in culture, in law, by the influence of famous leaders, good ones and bad ones. It could be, therefore, that the Act no longer teaches us well, and some evidence supports this conclusion. You will find discrimination still in America today. You will find racially discriminatory practices, both that aim at black people, as did Jim Crow, but also, too, ones that target white, Asian, and Jewish Americans. And the reigning ideology of so many powerful people today, anti-racism, explicitly endorses racial discrimination as a means to its utilitarian ends. But it seems to me that we can use my framework to identify things that have reduced the Act's effectiveness as a teacher of virtue. So consider disparate impact, which has actually required, in some cases, regulated entities to discriminate. So the Act has now been interpreted to both forbid and require discrimination, which makes its moral lesson unclear. Title VII's damages remedies now forbid certain conduct, which is not plainly and externally immoral, but internal and not necessarily plainly immoral, such as compliments in the workplace, which likewise makes the moral lesson of the Act unclear. Anyway, my ultimate conclusion is this. If you share my belief that laws have more than mere material applications and implications, before you may eliminate the Civil Rights Act and risk tearing down one of Chesterton's metaphorical fences, you must wrestle with the question of how the Act shapes human souls.
Thank you, GianCarlo. Thank you, Steve and Linda, also for inviting me. And I do recommend that everyone read GianCarlo's essay. It is very helpful, and it's unique, I think, in this area of scholarship. I have 7 minutes, so I'm going to limit my commentary essentially to 3 points. Most of my points will focus on GianCarlo's presentation, but I'll also incorporate some of my own work on the subject. First of all, I agree with GianCarlo that the Civil Rights Act of '64 is a moral teacher. Of course, the question is whether this is the proper place of the federal government to be teaching us morality, and I'll talk a little bit about that. I do want to begin, however, by just raising one minor, perhaps, quibble with this claim that we can't determine whether it is the act that is to blame for some of the problems that we all see. I don't think you could say it's the act, but I think you can say it is the revolution as a whole. So I do think it may be a pointless endeavor to pick apart different parts of the civil rights revolution, whether it's particular judicial decisions, executive orders, or the Civil Rights Act, the Immigration Act of '65, the Fair Housing Act of '68, but the entire combination of these judicial decisions, executive orders, and pieces of legislation have radically transformed our republic. And that is probably where GianCarlo and I will really depart. I see the civil rights revolution, and again, my interest is less in the act itself, although I'll talk about the act a bit. My interest is more in what the revolution did. And what the revolution did, essentially, is it replaced our constitutional morality with a new one. And that is a sense in which I entirely agree with GianCarlo's argument. But my point today is that this is not the constitutional morality that created and sustained the Republic until the 1960s. There was a displacement that I think GianCarlo is perhaps understating or even neglecting. What we have now essentially is a new moral order. So we have a moral teacher that has essentially created a new, and I would argue singular moral system, whereby we have a good axis, which is diversity, and a bad axis, which is discrimination. So anything that is discriminatory is bad. Anything that promotes diversity is good. This is not the country that the founders created in 1787. And I also don't think that this is the country that was envisioned by the 39th Congress that ratified the 14th Amendment. This is an entirely new order. And I think we could see this all around us. In this new order, it doesn't matter that we are dutiful patriots, that we are good Christians, we're good husbands, good wives, good parents, and so on. What matters is one thing, that we're anti-racist, right? And that is the system created by the Civil Rights Revolution, whereby diversity is the ultimate good, meaning anything that inhibits diversity is bad, and discrimination is the ultimate evil, meaning anything that permits discrimination must be eliminated. So what happens as a result of this new order? Well, that's something I've explored in my work. My point today is that that is a feature of GianCarlo's essay that is entirely neglected. Also neglected is whether the federal government has any role as a moral teacher. Pre-1964, it had no such role. You could search through American history. There is no precedent for the United States government having any authority in telling us how we should live our lives in terms of whom we associate with. The closest you'll get to is the 1875 Civil Rights Act, which was, of course, was invalidated 8 years later in the civil rights cases, an 8-1 opinion. And even that one justice, Justice Harlan, who thought it was constitutional, didn't consider it constitutional under the Commerce Clause, but rather under the 13th and 14th Amendments, under a rather strained interpretation of the enforcement powers that Congress had under those two. But no one thought that Congress was regulating interstate commerce when it regulated what a private business does on its own property. But all of a sudden in 1964, you get cases like Heart of Atlanta, and probably even more shocking, the Katzenbach case, which involved Ollie's Barbecue, a small barbecue restaurant in Birmingham, Alabama, that had not a single out-of-state patron in the year in question. But it bought chicken, not from outside of the state, from an in-state supplier, but that in-state supplier got some of its chicken from outside of the state of Alabama. And the Supreme Court said, aha, we have our interstate nexus. That is the damage wrought on our system by making diversity the ultimate evil. That we think this is legitimate constitutional reasoning, and a unanimous Supreme Court accepted that. And now what we have is a federal government that is essentially unlimited. So I agree with GianCarlo entirely that it is a moral teacher. I'm not sure I agree that the federal government is a moral teacher, in that that is a police power, and states have police powers, the federal government does not. So state anti-discrimination laws are perfectly legitimate. The 64 Act, however, does something that the federal government had never done before. And I think it's an important distinction, because when states do things, of course, we have exit options. When the federal government does things, we have no exit option other than leaving the country. What happens then is you get radical polarization, because then every single presidential election is going to determine what kind of country you live in. And that's what we see today. And that is Christopher Caldwell's point about polarization, right? He claims that the Civil Rights Act, and again, I do not identify the act itself, I identify the revolution, but Caldwell's point is that it creates a new set of winners and losers, and the legacy of being a part of the winning side and being a part of the losing side creates a sense in which there are winners under a new constitution, losers under the old constitution, and then we fight each presidential cycle over how to arbitrate our being on the winning side or the losing side. That is not a good moral teacher, right? And that's the system that we have today. Another feature of the Civil Rights Revolution, we've gained a lot in many ways. And we're all told this on a daily basis, all the great things that have come out of civil rights. I have 5 children, and they are told, every single February, all the great things that come out of the civil rights movement. What we do not hear about are the losses. What are some of these losses? Associational freedoms, and I'm not just talking about the freedom of association, I'm talking about religious liberty. I'm talking about contractual rights, property rights. The whole host of associational liberties that were fundamental to American life are all gone, essentially, right? Just look at what happened in Lakewood, Colorado, right? You could go to Jack Phillips and say, bake me a cake. It doesn't matter that there's another bakery, whose reviews are even higher on Google, by the way, less than a mile away. It is actually 3 blocks away. I've never been to Lakewood, Colorado, but I know how to use Google Maps. That did not matter. It did not matter, because we're not allowed to tell that couple there's another bakery, because under the Civil Rights Revolution, that doesn't matter. I could go on about other things that have been lost, freedom of speech, the public-private distinction, but that's something we can continue in the conversation afterward. Thank you very much.
So interesting. So a few things. So I would describe the United States as a liberal democracy, and I want to just define those 2 words. So the liberalism part means that we have protections of individual rights. I agree with Dr. Merriam that the role of the government is not as a moral teacher, but there is a role for the government to protect individual rights, including the types of rights that he is describing. Freedom of speech, freedom of religion, and also to be free from discrimination. I feel that we're having this context in a little bit of an ahistoric vacuum. In the 1860s, it was very acceptable for people to gather on Sunday after church while the body of a dead black man hung from a tree, and to take pictures in front of that body with their children while lynchings happened all over the country. That was perfectly acceptable in the 1860s. In the 1960s, this hotel would have likely not admitted Linda or I to be sitting here with you today. They would not have allowed us in or served us. That was all perfectly legal. It was the law. I don't think that's good. I don't think that that is a desirable path to go back to. The colleges and universities I graduated from, that Linda graduated from, the illustrious institutions in which she served would not have had her prior to the Civil Rights Act. And that would have been solely on the basis of her race, and that would have all been perfectly legal. So I think the Civil Rights Act does some important work. On the point of freedom of association, I I simply disagree. When we look around the country today, I've seen research, I've seen polling that says that 75% of white Americans do not have a single friend who is a person of color. So people are very free to be friends with whoever they would like to be friends with or not be friends with. What they are not free to do is spit at people, call them boy, beat them in the street, and have that be legal and fine. And I think, again, that is a good thing. There is a line in one of Dr. Merriam's papers that says that prior to the Civil Rights Act, discrimination in public accommodations were only regulated if it was a difference between life and death and cold and warmth, where it was really like an essential service, not like, a bakery 3 blocks away. In the 1960s, there was a movie that was poorly made called The Green Book, but it was based on a real concept, which is that it was a matter of life and death for Black Americans to have access to hotels, to have access to accommodations, to have access to food. People were restricted in their ability to move across the United States, which is part of our original Constitution. The mobility between states, that freedom of movement was limited for groups of people precisely because they did not have access to hotels, to restaurants, to the ability to travel and to live. Now, in your paper, you have this line where you say, the law's ability to change an evil custom depends on how strongly custom is held, who holds it, and with how much force they hold it. I think the evil custom of racism is a very evil custom, and I think it was very deeply held, and it was held with a lot of force by a vast majority of this country. And that is why we had lynchings. That is why when you look at the picture of the Little Rock Nine entering a school for the first time, that the Insurrection Act was called upon, where federal forces were needed to send to allow those students to integrate. And when you look at that picture, what you see are crowds of white people preventing their entrance into that building. So to me, that is a deeply held custom. And I do not believe that the law can or should demonstrate a positive vision of how we live together. I think it is just simply too big of a task for the law. I am a lawyer, and I just don't think the law can do that. I think that is something that we do as a culture. And I think whether we value anti-racism as the highest good or whether we value being a husband and a good Christian as the highest good is a matter of our culture. I don't think that is a matter of the law, and I don't think that is what the law is teaching us. What I do think the law can do is punish vicious external actions, as you framed it. And so the law can say, you can't murder people and you can't discriminate against people because you might get sued. That is what the law can do. But what the law has not done is desegregate our schools. We are just as segregated in our schools as we were in 1968. We had a period of decrease in residential segregation from 1960 to 1990 that has now increased. So we are, again, pretty segregated in where and how we live at a neighborhood level. And presently, more Republicans think racism is a problem against white Americans than against Black Americans. Maybe people in this room would not agree, but that is the recent survey in 2023 and their surveys going back that sort of demonstrate that to be a fact. And if that is the case, if people are concerned that racism against white people is a big problem, then I would think that the Civil Rights Act would be desirable because the Civil Rights Act would prevent such a thing from happening, as we saw with the student cases with universities and affirmative action. And I think it would be increasingly necessary as the demographics of the country continue to shift and become majority non-white, as women take up a larger portion of law school graduates and medical student graduates. I would think that preventing discrimination would be valuable. In my lifetime, the 2 instances outside of my professional life where I have seen the Civil Rights Act used were, one, I was a member of a social club called The Wing, which used to have a chapter here in DC. The Wing was a club for women and other gender minoritized people. There was a lawsuit brought pro se in New York City by a man, and the Wing was forced to allow men into the club. Similarly, I worked at an organization where I have to be really careful because there's an NDA here, but I saw a white employer give a black employee who was leaving severance outside of the severance policy. And he explicitly stated it was because she was black and it was as a desire for reparations. Another senior employee of color raised that concern to the board. That employee was fired. And due to the Civil Rights Act, that employee was able to get damages as a claim of retaliation for raising a concern about discrimination. On the left, I have been in like a gazillion conversations on anti-racism. I have never once heard the Civil Rights Act mentioned, besides the fact that it has not gone far enough in dealing with our history of racism and sort of the disparate impacts that we continue to live with today. And so it's really interesting to me to think about that as like the strand of evil. And I've been in a ton of conversations over the last year. Maurice Mitchell wrote a piece about the excesses of DEI and how it's destroying progressive organizations because of identity-based politics. He wrote a piece, I can find the name, but it's about resilience in organizations, and it's particularly about how identity-based politics are destroying progressive organizations from the inside out, and I have had that experience as well. So I think the concerns about DEI are well-founded. I'm not sure the concerns about the Civil Rights Act are at all well-founded. So that's what I'll leave with.
Thank you very much. Before we actually open this up to the floor for questions, I have a few questions of my own based on GianCarlo's paper, based on what I've read of Dr. Merriam's, and based on my knowledge of Aditi's work. So I first want to address a question, and I'd like both GianCarlo and Jesse to respond to this, that has to do with Dr. Merriam's concerns about the restrictions on freedom of association that occur because of non-discrimination laws, and how this, what in fact does have an effect on liberty interests. But I want to ask the question about whether or not there aren't sort of competing liberty interests, competing interests here for individuals. And would like to give the example of, I think as Aditi has suggested, private organizations, private groups having the ability to have freedom of association with whom, whoever the group intends. And the difference that restrictions in a more public setting, when those are not just strictly private organizations, but public or quasi-public entities, might have on restricting the right of access of an individual based on his or her color, and whether or not the sacrosanct notion of a freedom of association ought to prevail there when you consider other kinds of choices that individuals might encounter and make in their lifetime. The interests of liberty are certainly affected by an individual's choice of being able to or where to go to school, being able to apply for and compete fairly for a particular job. And is that liberty interest not equal to the right of the employer to only have people around him or her who look like that person or with whom they are comfortable? So first want to direct that to GianCarlo, and then Dr. Merriam, you can follow up.
Actually, do you mind, maybe, Dr. Merriam, if you have an answer, I'd like to think about it for just a second.
Okay.
Yeah, not a problem at all. So just 2 points to Linda's very good question. One, I think we should be careful not to think of this as a constitutional conflict. So if we just use the Masterpiece case that I just referenced, we oftentimes think of that as a constitutional conflict between what that gay couple experienced, the discrimination from Jack Phillips, and then the application of Colorado anti-discrimination law against Jack Phillips. And then we have to, of course, reconcile these two competing constitutional values. But before the Civil Rights Revolution, no one would have thought of this as a constitutional conflict, because one instance involves Jack Phillips, a private citizen discriminating. The Constitution doesn't apply to him. And the other involves the state of Colorado discriminating. This The Constitution does apply to the state of Colorado. So it is not a constitutional conflict. It is only because we have been imbued with the civil rights morality and we think of anti-discrimination as a result as a constitutional value that we start to think, well, this couple has a constitutional right not to be discriminated against, and Jack Phillips has a right of religious liberty. Uh-oh, we've got a constitutional conflict. Pre-1960, no one would say that's a constitutional conflict, which is why no courts dealt with such instances in those terms.
Could before you finish this, could I just ask that we try to frame our examples and our discussion on the issue of race?
Okay.
The Civil Rights Act forbids discrimination on the basis of race, sex, national origin, and in some cases religion, not in all of its provisions. But I think just to sort of keep us on the same track and focus, let's use your example. What if instead of that bakery not wanting to bake a cake for a gay couple, that bakery decided that they would not hire a black baker?
Or a white person or whatever.
Or a white person if it was a, right.
Still the same point, right? So I just wanted you to have it in your head. In one instance, the baker, whether it's a white baker, a black baker, or an Asian baker, right, is discriminating. No constitutional status attaches to him. In the other instance, we have the state of Colorado. The second point is anti-discrimination has moral value, of course. There are pernicious forms of discrimination that we've been talking about. That does not mean that it can't be calibrated. So I think this goes to your point before, that to preserve the freedom of association does not mean that we have to treat it as sacrosanct so that it always prevails. No constitutional value always prevails, right? But we would nevertheless honor its existence, which would mean that there would have to be, in some situations, some limitations on anti-discrimination. Now, you could imagine a host of factors that would go into that analysis. If I were in 1964, I could come up with a bunch. Now, none exist. The Act didn't put factors like, what type of service are we talking about? Heart of Atlanta is a pretty good candidate for applying anti-discrimination law because it's a motel that's doing out-of-state advertising. It's soliciting people to come into the state of Georgia and to use the motel. And there was the famous Green Book that African Americans had to use, right, to determine where they can get hotel reservations. Ollie's Barbecue is very different. Not a single out-of-state patron. It's a barbecue restaurant where people could all eat. They sat in different places. Not saying that's a good thing to do, but it is a different sort of thing than the hotel saying, you may not come here, right? So the Act could consider the type of service. It could consider the location. As I mentioned, Lakewood, Colorado, there's a bakery around the corner. Some parts of Colorado, there's not a bakery around the corner. That could also be part of the law's consideration. Animus, right, could be part of the consideration. Are you doing this in a hateful way or a non-hateful way, right? There is discrimination that is not necessarily pernicious or hateful. Heart of Atlanta sure looks hateful or pernicious, right? But we can imagine a whole host of circumstances that would not be. Point is, there are ways to preserve the freedom of association without treating it as sacrosanct so that anti-discrimination moral values could coexist with associational liberties. That's not the path that we took.
GianCarlo?
Yeah, so let me respond this way. There are two sort of debates that are going on side by side here, which are related but not identical. The question is, was the Civil Rights Act within Congress's power? That is a separate question from whether it taught a good lesson, in part. And the reason is that because although law must aim at the common good, it is also a requirement that the law be promulgated by the proper authority. So the claim then is that if the Civil Rights Act is not within Congress's power, it is not promulgated by the proper authority, and then it is therefore not properly law. But I agree with Dr. Merriam. There is a way to protect the freedom of association and also to deny to people a particularly pernicious choice. I think, reading just the text of the Civil Rights Act and not its subsequent judicial and legislative developments, which I know is frustrating to Dr. Merriam because you're looking at the civil rights regime, I'm looking at the act. And I think the Civil Rights Act does this fine. The Civil Rights Act does is it says private clubs may behave as they will, and it says whatever, it says within Congress's reach, we prohibit what we prohibit. Now, the court did go along and say the reach is a whole lot broader than you probably thought, Congress, when you enacted the act. But what the act is, so let me explain why this is, I think, frustrating to Dr. Merriam, and in part I share his frustration, is that the claim is essentially, it's really, if you're complaining about the civil rights regime, it's impossible really to separate the act from the subsequent developments and whatnot and whatnot. It's immensely difficult. I think that some people probably could do it. I don't know that I could. But I don't think that, as Dr. Merriam says, it's a pointless endeavor to try. And the reason I think that it's important, actually essential, that you do try is because if I am correct that the act did teach well, teach this particular virtue to the American people well, if you want to come along and say, well, we must get rid of it to get rid of the civil rights regime, you are risking then tearing down a Chestertonian fence, right? There's the possibility that if it taught well, and it still teaches well, this is a balance against tearing it down because of the implications of the civil rights regime. So I think it's necessary. And then you have to read the act on its text alone, right? Which is frustrating, I grant you, because there is a civil rights regime which far outstrips the act. But the problem of law developing or being warped into new ways is always a problem with law, but not a problem of law, right? The law is always going to be limited to its text. You will always have people who wish to twist the law, people who wish to change the law, people who wish to enforce the law in such a way that it appears different than its text. Consider, for instance, the FACE Act today looks very much, when enforced by the Biden administration, very different from what it looks like on text. Such is the nature of the problem with law. And so there is a constraint inherent in my approach to the act, which is that I am constrained by the act's text. But such as it is, if you want to figure out whether the particular law teaches well, you are constrained by the law itself, recognizing, though, that there are myriad other factors which teach as well alongside the law, and often, I think, teach more powerfully than the law itself does. But, and the last point, to one of Aditi's points, the law always teaches. The law is never neutral. To punish external vicious action is always to teach a moral lesson. Thou shalt not murder is not neutral. So whether the federal government had the constitutional power to teach morality this way is a separate question, but it certainly does teach.
Aditi, we're having this discussion about the Civil Rights Act at a time in which, when we talk about race relations, the topic, at least in conservative circles, maybe in non-conservative circles not so much, the subject of diversity, equity, and inclusion is always the framework in which we're making these judgments. And so I want to ask you, we've heard a little bit about diversity from Dr. Merriam, and I will come back to that in a minute, but I want to talk for a second about equity, particularly in the context of the Civil Rights Act of 1964, and particularly in the employment question, because there is a particular section of the law, 703J, which basically says that you cannot give preference in order to maintain a racial balance in making decisions about hiring, et cetera. And so I think when those of us on the right talk about equity, one of the differences we see between equity and equal opportunity or equal protection is an emphasis on whether one is granting access, providing opportunity, or one and guaranteeing that access, or whether one is trying to guarantee results. And so I'd like to hear from you a little bit about your own ideas about equity and what, as it's used in the DEI construct, equity means.
Yeah. So the way I've actually heard, the way I've heard it described for diversity, equity, inclusion, and belonging as like 4 things. And the analogy I've heard is diversity is being invited to the dance. Equity is having what you need to be able to dance, like whatever mobility aid you need to be able to dance. Inclusion is knowing the song that is playing, and belonging is being asked to dance. And so the pieces of this, which maybe is a clunky analogy, is that diversity is like, we're all in the room, but equity is like, are you fully able to participate given the historic constraints that may have been placed upon you? And the primary, and I really haven't heard many critiques of the Civil Rights Act on the left, but to the extent I've heard critiques, what I've heard is that some people in this country were given a 250-year head start, and then the Civil Rights Act basically like cast off the chains and put everyone at the same line and was like, go. And it really did not account for the differences, the aggregated sort of privileges that some people had accumulated versus others. And so when people talk about equity, the other kind of analogy you'll see for equity is you have like three people of different heights trying to look over a fence and putting like a box under people so they can see the fence. But when people talk about liberation, they talk about knocking down the fence entirely, right? Why is the fence there at all? And so in the context, I mean, I can talk more specifically in the hiring context, but like when we think about equity in the hiring context, and I have had that job and had to think about it very specifically, it's thinking about things. I can give a few really concrete examples. Like, do you actually need a degree to do this job, or does that just become a barrier to entry for people? And can you, if you are specific enough about the skills and qualifications, is that sufficient? Are we using sort of shortcuts as preferences, whether it's about where you went to law school or where you went to college? Like, we're putting people who went to Harvard and Yale at the top of the list, people with SCOTUS clerkships at the top of the list, but there are a whole bunch of things that create access to those pipelines for people that can be discriminatory kind of in the lead up to them. And then like other things, like they're just sort of biases that exist. So for example, we know that women apply to jobs when they meet 90% of the criteria, and men apply to jobs when they meet 50% of the criteria. And so adding like a sentence that says like, you don't need to meet all these criteria to apply, we would actually really like for you to apply, can help kind of counteract that. And so those are all things of equity that I see, and I think like the Rooney Rule, which comes from the NFL, comes from football, of trying to make sure that you were doing enough recruitment on the front end to have diverse applicants. And when I was at Protect Democracy and leading hiring, the biggest place we had the Rooney Rule was not for race, it was for conservatives. We were constantly trying to hire conservatives, and that was where we had the biggest challenge of, and so our biggest affirmative action that I've seen in the democracy space is for conservatives, always.
Let me just push you a little bit on this equity issue, because what you've described is mostly access. And I think what most of us who believe in sort of colorblind equal opportunity argue for is, I mean, I don't think I would disagree with you on access. I think there ought to be broader access. Casting the wider net is a great idea. But I want to hit specifically your analogy, which came from the original speech that Lyndon Johnson gave at Howard University about people who'd been chained and then brought to the starting line and unshackled and then expected to run the race. And my problem has always been that I agree with that. I agree you can't expect somebody to run the race if they've been in chains for 200 years. So the question is, how do you make them able to run that race, and giving access to and building skills in order to be able to run the race? But it doesn't seem to me, and this is where I think equity, as I view it, comes in, is saying, well, we're going to put you halfway down the field at the 50-yard line, and you're going to start from there, and then maybe you have a chance of winning the race. And I think that's what those of us who are concerned about notions of equity, when it's not equal access, but rather equal results that look at. So respond to that.
So I have never heard anyone on the left advocating for equal results as an outcome. That is not a thing I've ever heard anyone say or advocate. I don't know everybody, like, maybe some people are, but I have not heard that in the conversations that I have been in. But I think the question you're asking is a question we don't have an answer to. I think that and I think that's why we're in such a contentious moment. I think for the last 50 years, people thought that education was the answer. That if everyone had access to education, then you would begin to see like more equitable outcomes. You would begin to see, and we haven't seen that. We see that like Black women as a population are the most educated Americans, but that is not reflected in like senior leadership. It's not reflected in Fortune 500 companies. It's not reflected in upper echelons. We see that even amongst doctors and lawyers, more women are graduating than men, but you see there's a ceiling. People hit a ceiling, and I think the kind of contestation and the like contention that we're experiencing is people feel frustrated, because I think that for a long time people would say that, you know, you have to work twice as hard to get half as much, right? Like this was a rhetoric that was used, whether it's true or not, fine. But that's at least a predictable formula. I think the feeling and the frustration people have is that it's like question mark X equals question mark. Like people don't know how much harder they have to work to get what. And I think that unpredictability, I think, is where people are feeling a lot of frustration, and where I think you see sloppiness in endeavors and in efforts, because people like literally don't know what to do. They're like my best friend, went to college, she has a master's, she like has her PhD, she's like getting her PhD right now in education, she has like every certification, she's a Black woman, every certification that exists as a teacher. And in every school she's worked in, she has faced racial discrimination, she has been called the N-word by her students, her administration has not stepped in to do anything about that. And so for her, she's like, I don't really know what I'm supposed to do here. I did the thing I was told to do. I went and I got my degrees. I am more educated. I've done more professional development. I know my craft and my skill better than every white counterpart that I coexist with, and I get more shit for it. And that is a tough place to be. And so I think when we're talking about policy and law and reparations and like the sloppiness you're seeing, what you're seeing is like, I think like a scream of deep frustration.
Let me turn the
Linda,
question back to the Civil Rights Act, if you don't mind, and I want to pick up on something that Dr. Merriam suggested, which was that states can pass non-discrimination laws, but there shouldn't be a federal anti-discrimination law. Well, that was in some sense the regime we lived in prior to 1964. There were state laws involving discrimination, but it was to discriminate in major parts of the country in the Jim Crow era, to discriminate against Blacks. If we were not to have a federal non-discrimination law, would you be open to the idea that some states could go back and enact laws that could discriminate on the basis of race?
So first of all, there were state anti-discrimination laws. The first one was a 1945 New York employment law. It just wasn't as vast as the Civil Rights Act, obviously. Even within the state of New York, it was limited to employment. It was essentially a Title VII for one state. And other states picked that up. What no state had done was the vast, public accommodations, funding, education, and employment regime created by the '64 Act. What could be done also, just to get back to your question, is the calibrated approach, right? It's to recognize not all public accommodations, not all employers are engaged in interstate commerce, but certainly some are. Heart of Atlanta is very poorly reasoned as an opinion, but it's a justifiable result. So you could certainly create an act that actually limited public accommodations to instances where you solicit out-of-state patrons, you have out-of-state advertising, as Heart of Atlanta did. Now, it'd still be a much more complicated Commerce Clause analysis. Is the decision not to have someone in your motel actually an economic activity under the Lopez test, right? So the decision not to get health care, not an economic activity. Likewise, you could argue the decision not to do business with X person is not an economic activity. Point is, there is a version of the 64 Act that calibrates, as I said, associational liberties with anti-discrimination values, and that is confined to the powers that Congress has, even under the New Deal regime, right? So you could create something that worked within the New Deal regime that limited anti-discrimination norms to instances where they were actually operating, in some instances, outside of the state. I don't think Ollie's Barbecue could be reached on that basis. I think Heart of Atlanta probably could. So it doesn't mean 64 Act entirely is unconstitutional. It means you need a much more modest version of it.
Linda,
And
can I
you're
jump
talking
in?
mostly about public accommodations section.
Employers too. Not all employers are engaged in interstate commerce, right?
Well,
so Title
no,
VII
but
and the spending clause
It is already limited on employment by
to
size.
15. Yeah, but
so-
I don't know. And sorry, one more thing. And then the spending power is also really vastly expanded. Any institution that gets federal funding, which is going to be every public school in the country, just about every university in the country, except I think it's 3, they're going to be subject to it. That's a very broad interpretation of the spending power.
Title VI, right. GianCarlo, I wanted to ask you, given some of what you said in your paper, but also reflecting on some of what's been said up here, the Civil Rights Act, as it was written, is one thing, and I'm old enough, Aditi, to have actually been around and cognizant. I was still in high school, but I was a student member of CORE at the time, so very aware of what was going on in Washington on the Civil Rights Act. But the Civil Rights Act is one thing as it was passed. It's quite another thing in terms of the way it's been interpreted by the courts and by executive agencies in particular. So, GianCarlo, what I wanted to ask was, given current jurisprudence and executive interpretation, particularly thinking about something that Aditi alluded to, which was disparate impact, what changes could you imagine might be a good idea in terms of the Civil Rights Act? We've already heard some from Dr. Merriam.
Yeah, so let me, in answer to that question, let me sort of retell the story of what has happened post Students of Fair Admissions. So you remember Students of Fair Admissions, the court's previous decisions with respect to permitting racial preferences in college admissions were framed as an exception for universities and universities alone to the Civil Rights Act and the Equal Protection Clause, which of course were conflated in the Bakke decision and joined as one. But the point is they were an exception. So the Students of Fair Admissions decision has no direct legal impact whatsoever on, say, for instance, employment discrimination. And yet, in the wake of that decision, what happened was that law firms all over the country started producing endless memos about whether or not Students of Fair Admissions affects DEI policies. Many of them concluded that, yes, they will affect some DEI policies. You will have to cabin these kinds, affinity groups, for instance, employment preferences, benefits, et cetera, on the basis of race. Why? Right, the decision had no direct legal impact on employers, and yet the law firms, chat rooms, what have you, blogs were all about this. Why? Well, because what I posit, and this makes sense under the framework that I adopt, is that what the Students of Fair Admissions did is rehabilitated, in a small measure, the pedagogical effect, the teaching ability of the act. It reminded people, in essence, that discrimination is forbidden by the act, and it eliminated one of the conflicts which subsequent judicial interpretations had created, where it said in this case discrimination is permissible, but discrimination is otherwise not permissible. And you can see if you have a lesson, an act interpreted, which teaches the same lesson in opposite directions, it is not teaching a clear moral lesson. But having removed that, suddenly the moral lesson of the act is clear and people are reacting to it in places beyond the act's actual legal operation, beyond the decision, Students of Fair Admissions, legal operation. So there's a teaching effect. That is explained as a teaching effect, I would argue, not as a legal effect. So if you want to make other changes to the Civil Rights Act, what I would do is I would say which subsequent developments have with respect to one of the 4 elements of the framework, has it diminished the Act's teaching effect? So for instance, Title VII's damages remedies amendments in 1991 outlaw all sorts of behavior which is not plainly and externally vicious, which means that the Act is sort of trying now to teach lessons to angels rather than to men, which is not an appropriate use of the coercive laws. The disparate impact processes here, there, and everywhere do the same thing as the Students for Fair Admissions did, right? They sometimes require employers to discriminate to avoid anti-discrimination liability, which means the Act is teaching opposing lessons. So that is what I would do. I would go through the various judicial amendments and legislative amendments and see, have they in some sense hindered the operation of the Act with respect to the 4 components of my framework. Now, let's say you went and you cleared out all the subsequent judicial decisions, the 1991 amendment, right? Everything that Gail Heriot has lamented for years. If you cleared all those out, what would happen? My framework would posit that you would probably see more of a return to the original civil rights vision, which places the locus of morality in choice, not in outcomes, and on individual behavior, not on collective material results. That's what my framework would predict. Maybe you wouldn't see it, right? Maybe you wouldn't see it for a variety of reasons. Maybe the people have changed such that the Act is no longer responsive, maybe or communicative. Maybe other interests, other teachers have come along and just simply overrode it. In which case, then you might consider eliminating the Act. But until you can isolate the effect of the text from the subsequent developments and are sure that it is no longer teaching well, I don't think it is wise to throw the Act out in order to get at what may be caused by subsequent developments.
I have lots more questions, but it would be unfair to all of you who very patiently sat by. So I'm going to open up the floor to questions. And make sure it's a question, keep it short, and keep your answer short, and you may direct it to any or all of the panelists.
Thanks so much, and thank you for all of your comments to each panelist. Each of you has touched on, in various ways, but never directly, the question of putting aside constitutional structures, history, all of which is important. When should the law enforce morality? That is a lurking question behind each of your comments and perspectives. And, is it the John Stuart Mill principle? Is it something else? And I'd love to hear your thoughts on that question in this context. What's the trade-off? And then in the course of it, to answer a specific case hypothetical. Say there's a partner in a law firm, senior partner, who chooses not to attend mandatory DEI training and says, and assume the person is a white male, a straight white male. This is not taken from experience. This is a hypothetical. Assume that straight white male not only doesn't attend, but says in partner meetings that he thinks they are a bad idea and discriminatory, and he sees what you see as access, he sees as results. I think some people see access, some people see results. He says it's results-oriented and a bad idea. Should those facts be evidence if, in a subsequent Title VII case, the firm of which he's a decision maker, one of many, is sued for racial discrimination? Thank you.
I'm going to throw that first to GianCarlo, but then I'd like to hear Aditi weigh in as well.
Okay, I'll take the first question. I'm not entirely sure about this. The second question seems to me more sort of a focus on, like, the doctrine of Title VII as applied, which I will leave off. But on the first question, the question is, when should law teach? Bear in mind that law always teaches as long as it is known. Sure.
There's a connection between the two, which I left out. The reason liberals used to hate the idea of the law enforcing morality was that it impinged on private conscience about who they should have sex with, for example. The reason conservatives now hate it is because it impinges on their sense of what's right in the context often of identity politics. So I tried to come up with an example where there was an individual conscientious objection, but in the context of a workplace. So is it prejudicial in the case to allow it in evidence, or is it essential to get it into evidence to find out the character of the decision maker?
I guess I'm having a bit of a difficulty understanding quite what you're getting at. Do you maybe want to give it a shot?
Yeah. So to me, what I'm still the liberal who thinks the law should not enforce morality. I'm scared you're gonna all make me go to church. I don't want to go to church. So like it's not for me. In your example, there are a couple things that I would like to suss out. One is I don't know the data on DEI trainings well enough, but I know sexual harassment trainings are completely ineffective. And I would guess that DEI trainings are also extremely ineffective. So I'm like not yay DEI trainings. I kind of don't give a shit. I don't think they're doing anything. In your example, my question would be, I don't have a problem with this hypothetical partner at the law firm having whatever views he has. There are probably a lot of people in our country who don't like other people for whatever reasons. They might be kind of based on these more descriptive characteristics, but Taylor Swift fans really don't like Jake Gyllenhaal and they're allowed, it's fine. But the difference is that Taylor Swift fans cannot buy a ticket to a Jake Gyllenhaal movie. Which again, we're free, freedom of commerce, you're allowed. What they can't do, which this partner at this law firm can potentially do, is pay his white and his black employees differently. And so that to me is the question, that I think it becomes relevant if it becomes evidence of animus, and it depends on what is the fact pattern that's sort of happening the rest of the way. Because if what you're seeing is that if what's being alleged in this law firm, I'm just using this as an example to try to extrapolate on your hypothetical, is that white and black employees in this law firm are being paid differently, promoted at different rates, even when they're doing the same work, assigned to very different types of cases, and he's the one making the decision, I think that's a relevant fact. And so to me, that's the question. Now, if there is one person who's saying, I should have been promoted, but I wasn't promoted in a completely different part of the firm that he's never interacted with, had no decision-making power over, and that person is the anomaly in the fact pattern, then I don't think it's a relevant fact. And I think that's why we have legal processes to suss exactly that out.
So I see. So the question really is his refusal to participate in the training probative of discriminatory intent? That's the question. I mean, if it's based on a principled objection, I see no reason why it would be, but that's just my personal 2 cents.
It depends on if he actually did the discrimination or not. Did he do the racism? That's the question.
Could I just throw, as the prerogative of the chair, another response, which is, I don't think that any law should prohibit what you think and believe. And I don't care what an individual thinks or believes about me based on my ethnic background or anything else about me, gender, anything else. What you're not allowed to do is to act differently in certain contexts in terms of an employer. And if you treat me differently based on some prejudice that you have, you can keep your prejudices, but if you treat me differently and behave differently, then that's where we come into
So
the
this
law.
is, I think, the core of the problem with the difference between the text of the Civil Rights Act as written and what Dr. Merriam rightly describes as civil rights revolution. There has been a shift in where the locus of morality lies. The text of the Civil Rights Act, as is, places the locus of moral import on choice, right? Individual action, as a choice as represented through individual action. The Civil Rights Revolution, Dr. Merriam is absolutely correct, places the locus of morality in outcomes, which are typically measured across groups defined by ascriptive bases. And I completely agree that that is not appropriate.
Let's go to the next question.
Thank you. For GianCarlo, thank you so much for coming and presenting that
Thank you.
very interesting paper. Let me challenge you slightly based on the work of Tom Sowell, very highly regarded Black economist who lived this period from Howard to Harvard to the University of Chicago. He's now at Hoover. His work on the 64 Act, if I could just thumbnail it, is you look at the experience of blacks during the terrible 1950s with Jim Crow, there was galloping progress on a socioeconomic level. When the '64 Act was passed, and through the 60s and beyond, it slowed down. And his view is, look, although it may have universal language, the message was, this is the only group that can't make it on their own, they need government assistance, and then it instilled that sense of victimhood in the black community and reliance on government. Does that change your mind at all about the '64 Act?
No, and let me explain why. It may very well be, and in fact it is correct, that material outcomes for African Americans were improving in many measures up until the passage of the Act. But insofar as the claim is that the Act was necessary to continue those material developments, my answer is maybe, right? Maybe it was, maybe it wasn't. Maybe poll workers would have just sort of stopped discriminating on their own. Maybe Southern legislatures would have chosen on their own eventually to repeal segregationist laws, et cetera. Maybe the Civil Rights Act was not conducive to the material outcomes of black Americans. But my point is that material outcomes are not the end-all be-all. In fact, they're not even what I'm most concerned about here. My response is that insofar as you arguing that the Act was not necessary, necessary is the wrong word when you're thinking about human virtue. Let me find the point. I'm better on paper, so let me find the point in which I make this clear. Right, so if, as Aquinas says, the purpose of law is to make men virtuous, then it's really immaterial, their material outcomes, and it's also immaterial whether other things are also making them virtuous. If the law can do so, and can do so effectively, it is good that it try.
Let's go to one last question I think we have time for.
Sorry, I apologize if I mispronounce your name, Ms. Juneja. So you said something earlier that you feel that in liberal spaces you haven't heard a push for equality of outcomes. And I was hoping you might expand on that, because from my perspective, disparate impact is something that's pushing for equality of outcomes. And I'm very accustomed to being in spaces where they're, people point to something, say, if women aren't 50% represented, why don't we have 20% of our workforce be black? And it's like, it's never adjusted for age, never adjusted for the proportion of people graduating from these programs, and in many cases it's used against what you were talking about, which I agree with strongly, this idea of alternative credentialing or qualifying for jobs based on experience, or in some cases, aptitude tests. So I was hoping that maybe you could expand on your remarks about that, because I see these as in conflict with how the law's been interpreted.
Yeah, I think it's about the way we think about and talk about these things, which is like very rooted in the historical context. So when I'll just take the example you gave of like, why don't we have 50% of women in whatever company or in the C-suite or on a board? What you would hear on the left is people would say that the reason we don't have it is due to systemic failures, that because we don't have paid parental leave, because women like leave because we don't have affordable childcare, women are still doing more domestic labor than men, and therefore women hit a certain point in their career, and you see it in the data that there's a motherhood, that the gap is in motherhood, not in marriage, right? And so you would point to that, and so from the left perspective, what you would say is that the failure of the outcome of 50% of women is a systemic failure, that there is something that is happening before you get to the outcome point that is a failure, that is inequitable, that if men and women both took parental leave and took the same amount of parental leave, if childcare was affordable and available to everyone, you would see women represented at 50% of those levels, which may not be true, which you can disagree with, but I'm saying that is the perspective, that is the analysis. And so when people are talking about disparate impact, to use a different example, when you're talking about arrests for drugs or you're talking about incarceration, you will say white people use drugs at the same rate as black people but do not get arrested at the same rate as black people for using those drugs. And there are reasons for that. Some of that is about where police. A lot of that is about whether people are using their drugs in public or in private spaces. But people would say people's ability to use drugs in public or private spaces is about whether they have access to public or private spaces, and that is about money, and that is about the history of this country. And so all of these things, which again, you don't have to agree, but I'm saying when people are pointing to disparate impacts and the outcomes, it is because they think a problem happened earlier in the food chain that led to that disparate impact, and that is what should be corrected for. I have never heard someone say that, like, and when they are trying to make an adjustment about, like, we should make sure we have 50% women, it is because people are trying to correct for a systemic failure. But I think the vast majority of people I know would far prefer that the systemic failure be corrected earlier in the process than to correct for it on the back end.
Can I make a quick point on that?
Sure.
I think it's true that the left is not concerned with proportionality. So if you look at the Harvard affirmative action case, under 40% of the student body is white. No one mentions that. So they're clearly not concerned with proportionality at this point. If they are, it's an asymmetric concern. Stanford, by the way, is 22% white. No one talks about that. So this is not a country that is concerned with the proportionality of representation at this point.
And the most underrepresented group in Congress is blue-collar workers. No one is worried about that. So.
And they're also underrepresented in elite universities, I might add, the children of such workers. Thank you so much.
Please join me in thanking this fantastic panel. And I wanted to thank all of you for joining us today in person, those of you who joined the live stream, and those who will listen to this later on. Thank you very much. Thank you so much.
I'm glad. Got a little fiery.
That was great.